Ready? 5 seconds. Start. It was averred in the complaint that the petitioner was not a man of good character and he had relations with other girls. He is said to have been involved in a murder case earlier. He was the main accused in that case and the police had been searching him. A Muslim person who was going on a bicycle was murdered in Mahesh Nagar and his dead body was thrown on the railway track. But as the petitioner had contacts at the higher level, he remained absconding from the office as well as residence and had also left his sister at Jaipur. Later on, the said criminal case was dropped on account of some recommendation. Apart from it, it was mentioned in the complaint that the petitioner was involved in Jaipur communal riots during which he had burnt down many shops and his leg was also got burnt. Para. The learned counsel for the petitioner has submitted that the impugn order of charge is not sustainable in law as being contrary to the relevant provisions and material available on record. Further, he has submitted that the learned trial court has not properly considered the facts and circumstances of the case and also the statements of the witnesses. According to him, there are three types of statements, namely that of friends, neighbors, and the relatives. He has submitted that the charge had been framed against the petitioner by the learned trial court on the basis of surmises and conjectures. It has also been submitted that the deceased and the petitioner had cordial relations. It was a love marriage between them and that the deceased had left a suicide note. On the basis of the statements of the witnesses, the learned counsel for the petitioner has submitted that no offence under sections 498A and 306 IPC is made out against the petitioner. It is submitted that the petitioner has neither instigated nor abated the deceased to commit suicide. Para. Insofar as the submissions made by the counsel for the petitioner in respect of witnesses and their statements, I am of the view that the credibility and reliability of the same would be considered at the stage of trial. Even in cases of love marriages, it cannot be presumed that no dispute arises resulting in death of the wife or that matrimonial offences are not committed. Circumstances subsequent to the marriage are relevant to consider as to whether any offence has been committed or not. As regards the submissions made by the counsel for the petitioner that in the instant case the alleged offence is not made out because there is no evidence with regard to abatement or instigation, suffice it to say that the offence of suicide in relation to dowry death or death of the wife in unnatural circumstances within 7 years of marriage has, with the amendment in the Evidence Act, attained new dimensions and significance. As referred above, after amendment, in a case of suicide, a legal presumption is to be drawn. Stop.